First one to talk about is jurisdiction. And it's not as a defense as they say. It is an affirmative defense the employer and carrier would have to prove, but it's basically this. For Mississippi workers' compensation law to apply, your employer must have 5 or more employees. And if it doesn't, and you have not voluntarily elected workers' comp coverage, then you can say, I don't know your comp benefits. And you can say, I'm not subject to whatever the Mississippi Workers' Compensation Commission says I owe you, because you've not qualified under the statute to have jurisdiction. Now, you can have one employee, and you can then buy workers' comp insurance. You have then elected or volunteered yourself to be covered under the Comp Act. So be careful of that. The second thing is, in Mississippi, there is not concurrent jurisdiction with the waterfront. And when I say that, when you get injured working on a ship on the shore, you're covered under the Longshore and Harbor Workers' Compensation Act. I think Carl's going to talk about that a little bit later today as well. So if you're covered as a longshoreman, you are excluded from coverage under workers' comp. You don't have to pay both benefits. Now, if it turns out you got paid under one, you should have been paid under the other, you can take credit as an employer for paying the benefits. But at the end of the day, you're only in Mississippi subject to one of the laws, either workers' comp under the state law or the Longshore Harbor Workers' Compensation Act. And then, of course, if you're off the shore and in Big C, that would be what we call Jones Act. And again, if Jones Act's going to cover it, then Mississippi state workers' comp law will not. So again, around here, especially with the waterfront, you really have to ask yourself, is this a comp claim, or is this a longshore claim, or is this a Jones Act? There's also the owner exemptions, and I know Carl talked about that case earlier today, where the owner of the business and some of the folks said he claimed is exempt because he didn't buy the insurance. There is a form that is to be filled out by an owner to validly claim an exemption, and if somebody as the owner and or executive management, if they own a share, can exempt themselves from coverage. Now, the downside is let's say you got 3 owners and 2 employees, and all 3 owners exempt themselves from coverage. You still have 5 or more employees under the statute to have the Workers' Comp Act apply to your company. You just don't have to pay a premium based on the 3 excluded employees that own the company. And that will save you premium dollars, but you're still going to be subject to the Comp Act.